Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments. I am here every night around 9 p.m. Eastern Time to answer your U.S. immigration related questions. And tonight I have a great topic for you. And this is, can you stay in the US and apply for your green card, or must you go in order to finish your green card process? This is basically discussing adjustment of status. That's the process of staying in the United States and applying for permission to work, and while you're waiting to get your permanent residence here. Or consular processing. That's a process of being in your country, staying in your country, and finishing your permanent resident process there. And this question is very important, especially for those of you who are thinking about coming to the United States. You want to determine whether you can stay here and apply for permanent residence to be with your family, or whether you must go to or stay in your own country and wait for the permanent residence process to be completed there. So it is one of those very important questions to answer. And I also want to let you know that I'm going to discuss this in very general terms. If you are in a situation like this, this is where you will need to get legal advice and representation through your process. You can always do that by going to the link in my bio, and it will take you to the website where you can schedule your own appointments. You can call by going to the website. You'll get the phone number there. You will also see my phone number on my videos on Instagram and YouTube. My number is 561-405-4889. And you can go ahead, contact the firm, and schedule your appointment. Now, should you stay or should you go? Most people would really like to stay, especially if they're already here. And some people are in a certain dilemma where they are here and they've already overstayed. They cannot leave, or they will face a ban. So I'm going to discuss all of this. Let's start with adjustment of status. That's the process of staying in the United States and applying for permanent residence here while you get to stay with your family. You get to work here and wait for your process to be completed. Is that a possibility for you? It may be. Now, it may be if you are here, you have current status, you have an approved I-130 petition already, and your immigrant visa number is current. If all of these conditions are right, then adjustment of status may be for you, where you can stay in the United States and apply for permanent residence and a work permit here. Now, if you are here without status and you really would like to figure out your options to stay here and apply for permanent residence, it's going to come down to your particular circumstances. There are ways. This is where it's very important to schedule a consultation, because those ways really come down to your personal circumstances and even who your relatives are. If you are the immediate relative of a U.S. citizen, you're out of status, then that may be a possibility for you. Adjustment of status, that's a process of staying here, applying for your permanent residence. If you came in with a visa, it's just that now your visa has overstayed. It's going to be different though if you came and snuck into the country by boat or by crossing the border. But if you or if you were not inspected at the border. But if you came in, you were paroled in, you were given permission to come in, you were given a visa and you came in with the visa and it's now expired, and you're the immediate relative of a U.S. citizen, then staying here with your family members, staying here is a possibility. And you can get your work permit while you do that. Now, who is the immediate relative of a U.S. citizen? It's not every single relative of a U.S. citizen. It's going to be the spouse of a U.S. citizen. It's going to be the parent of a U.S. citizen, and that U.S. citizen is age 21 and up. Or it is going to be the son or daughter of a U.S. citizen who is under 21 and unmarried. If you fit within this criteria, you came here with a visa, even if it has now expired, then it may be a possibility. Now, if there are other factors that are affecting your decision to go ahead and apply for adjustment of status, like you've had an arrest in the past, or you are hesitating because you're already out of status, that's where you need to schedule a consultation. Being out of status alone shouldn't necessarily stop you from applying for adjustment of status. However, if there are other factors, schedule a consultation. Being arrested alone, having a conviction is not by itself going to make you ineligible. It's going to come down to the facts when it comes on to other issues, other types of immigration violations or criminal issues. Now, if I had mentioned before that if you are maintaining legal status here already, you have an approved I-130, you have, and your priority date is current, then you could possibly adjust status. What does all of that mean? Right? And I'm going to break this down for you. So when you are applying, other than being the immediate relative of a U.S. citizen, when you're applying through relatives or through an employer, you must have a current priority date. That means that the date that is on your receipt notice is the date that they're currently processing. There is a website where they publish these dates to show what dates they're publishing. If your date is on or before the date that they currently have on their website, that means your priority date is current. So if you find yourself here in the United States, you have legal status. Say you are on a student visa. Say you are on another type of employment-based visa, like an H-1B visa or an O-1 visa. Then if you fit within these conditions and your conditions are right, then you could stay here and apply for permanent residence. But let me remind you that you should always schedule a consultation because even one fact that is different can make a world of a difference in the type of advice that I'm going to give to you. I'm going to take pause to answer some questions. Let me remind you that I am both on YouTube and I'm on TikTok tonight. Go ahead, put your questions in the comments. I will answer your questions as they come in, and it does not have to be related to the topic that I'm talking about. So Queen Bee, I see just visa. I didn't see the other part of your question. So go ahead and can you retype that question? So NY11432, U.S. citizen apply for parents and parents have under 18-year-old children. How will it work? Thank you. I'm glad that you have brought this up because if the parents have any children, so if a U.S. citizen, son or daughter who's 21 and up applies for the parents, unfortunately, they would have to submit, hi there, Dark Horse 45, they would have to submit two applications for the parents, so mother and father. Unfortunately, immediate relatives of U.S. citizens cannot include dependents or what we call derivatives in the application. This is the one category that does not allow you. Hi there, Nikki Z. Thanks for the share. This is the one category that does not allow the immigrant to include a dependent or a derivative. I know it is one of those crazy parts of immigration law that can be heartbreaking because the parent can have small children who don't have status and they can't bring them along, unfortunately. So they wouldn't be included. So kabongoj, no. So if you buying a house alone here is not going to, buying any property here is not going to give you residence. Now, there are investor visas and investor green cards, but you have to make sure you go through a specific process and it's not going to be a passive investment, meaning you just buy property and then It's not an ongoing business, but the money comes to you, say for rent. So if you buy a house, you rent the house and you get the rent. That's more of a passive type of income, and that's not necessarily running a business, right? And so it's not going to count as a part of the investor's green card or investor visa. However, if you're running an active business or if you invest in an active business and you meet the income, the requirements, the investment requirements for those, then that could be a possibility. What about if the family member is not a citizen and they are filing and the priority is current? So Keisha, if the family member is not a citizen, that would mean that you'd fall into another category. So if they now it is current, but is your petition approved? Because it's at the point that your petition is approved, that means that they're ready to go on to the next step. And you yourself have to maintain legal status in the United States. So at the time that you're here, you have to make sure you can't overstay. The minute you overstay, even by a day, and file the adjustment of status application, is not going to be valid. This is a part of the immigration law that you have to be very careful about. And this is where you should independently make sure that you get legal advice. You can always schedule with me to talk about where your case is, what your situation is, who the relative is, to determine whether adjustment of status could be a possibility for you. I got married last month to a citizen. My daughter is here on vacation. Should I let her stay? So Nikki Z20, no, it depends, right? I know circumstances change. But if you married a citizen, your daughter is not necessarily going to automatically qualify. Remember, I had mentioned before that if your spouse files for you, you can't include your daughter on your application because you're the spouse of a U.S. citizen. That means you're the immediate relative of a U.S. citizen, and they don't allow for dependents or derivatives. However, if your daughter is the stepchild of a U.S. citizen, that means that at the time that you got married to your U.S. citizen spouse, your daughter was under 18, and your daughter is now unmarried and under 21, it may be a possibility for her to stay. But I would have to determine whether this would work for you. Nikki Z, get legal advice. It's very important that you get legal advice before making decisions like this about staying or whether you go, because if you don't make the right decision as to whether to go or stay, it can have detrimental immigration consequences in the future. So in your case, while it may be possible if she qualifies as a stepdaughter of a U.S. citizen, it's going to depend here on your circumstances. And this is the exact topic that I'm talking about, actually, is should they stay or should they go? So let me talk about that, right? So in this case, if she's the stepdaughter of a U.S. citizen and she's here on vacation, now if your circumstances have changed and you are really and she qualifies for adjustment of status, that's where it could be a possibility. Now keep in mind that there are other things to be mindful of. When you're applying for adjustment of status, you also have to be mindful of whether this can affect the officer can make a determination as to her intent, or when she was coming into the country on the B2, whether she intended to stay. And so that's where the evaluation is going to be very important, to make sure that your daughter does not fall within any red flags that will cause some difficulties during the green card process. Keep in mind that many individuals have gone through this process successfully. And usually what happens is exactly this type of scenario where the child comes here to the United States and circumstances change. You want to be with your child. Maybe something has occurred where you can't send your child back to their country, and you decide at that time, after they actually come into the country, that you're going to file the adjustment of status. So in a case like this, it could be possible as long as you meet those as long as you can meet those conditions. All right. All right. Keep those questions coming, because I'm here to answer your U.S. immigration related questions. So I am going to continue talking about, I see some more questions here. So let's see. So I got married in November. Do I have to be on my husband's phone line? So Dainty Brown, get legal advice. That is too specific for me to answer here. Now, what I often say is when you're applying for the marriage-based permanent residence, you have to make sure that just live like a married couple. Do everything like a married couple. If being on your husband's phone line isn't necessarily required, but what else are you doing as a married couple that a married couple would usually do? Some couples don't want to have joint bank accounts. That's okay, but in other cases, you may have a property together. You may be on the lease together. All of those can still be strong evidence that you're a married couple. So it really comes down to how the both of you want to live as a married couple. But there's not any one piece of evidence that's absolutely required. However, what the immigration officers do ask for, what they commonly ask for, are insurance policies to see, has your U.S. citizen spouse added you to their insurance? Have you had shared property like a car or a house or land? Are there friends and families on both sides, on both of your sides, who can attest to the relationship that you have? Are there any joint bank accounts, right? If you do have while joint bank accounts aren't required, if you do have joint bank accounts, are you actively using those bank accounts? Are you exchanging money in other ways, like through Cash App, Western Union? I know Cash App and Zelle, those are popular ways to exchange money, and even spouses exchange money in that way as well. Are you filing joint taxes? So those are some of the common types of evidence that they ask for. Is the K-1 visa quicker than the spousal? Right now it's a tad quicker. You could be looking at an 18-month process for K-1 visas, where the spouse is about 18 to 24 months right now. I am doing good. Should we get married in his country or USA? I see. So we can live here in the USA. So you can get married in whatever country that of your choosing. You could get married in his country. And this is what the Immigration Service looks for, is as long as the marriage is legal in the place that you got married, in the country that you got married, then they will accept that as a marriage. So that is what you have to be careful about. If you have an informal ceremony where you get married that way, then you should not be doing that informal ceremony. But you have to make sure you comply with the laws of your country to do a legal marriage. So that is accepted by the US. I have a tourist visa. I want to get married to my US citizen boyfriend. Should I do it in the USA or my country? So Jesse, that's where you need to schedule a consultation. This is where you have to be very careful. When you come here on a tourist visa, and you get married within, so they have what's called, it's an informal rule called the 90-day rule. And if you do get married within those 90 days and then you file right away, what can happen is you can be flagged for misrepresentation, for representing that you were coming in temporarily when from all indications your intent was to get married and file your papers here and stay permanently. So while that doesn't necessarily have to be the case for you, I would want to do a personal consultation to ensure that the conditions are right for you and to assist you to apply, whether you're going to decide to apply here or apply in your home country. Now, if immediate relatives of U.S. citizens do have the right to apply through their spouse, in their U.S. citizen spouse, and to adjust status, even if their status expires. But the way you go about it can also have negative implications if you are not careful about that. And so you should get legal advice, legal representation to make sure that you are good through the process. And so that's where you're going to have to, it's going to come down to the circumstances. How long ago did you enter the country? When did you meet your spouse? How long have you two been together to determine whether it is right for you to get married and do adjustment of status, or get married in your country and do consular processing. Green card holder apply for his or her under 21 years child. How long will it take? So you're looking at about 18 to 24 months. I have tourist visa and I want to get married. I answered that. How long does a tourist visa take? It depends on the embassy that you're applying through. How do I obtain a tax ID? So you'll have to contact a tax assistant agent. How long it take to get work permit once I applied for adjustment of status through marriage. So right now you're looking at between 4, so you could be doing 4 months to anywhere to 11 months. It depends on the service center, but they are backed up right now. What is the process for sibling filing for sibling, and can the spouse be of the... So this once a sibling files for the sibling, the spouse can come along. Keep in mind that it is a 14-year process. Usually it starts with the sibling, who is going to be a U.S. citizen and 21 and over, applying by submitting a petition. That petition is going to take years to get approved, and then another couple of years, a minimum of 14 years to actually go through and be fully processed. So what if they passed my priority date? So you may be current, Keisha, but whether you can file is going to depend on your circumstances. How long does the tourist visa take? So the tourist, it depends on the embassy who you're applying through. So official J. Williams, you are welcome. All right, so I am going to just quickly touch on consular processing. So if you don't fall within the category to apply for adjustment of status, remember, there are 2 ways that you can qualify for adjustment of status, and it's going to be: 1, if you are currently maintaining status, your priority date is current and you have an approved I-130. If you fit within these conditions, then that could very well be a possibility for you, but you should still schedule a consultation to determine whether it will work. Now, if you don't fall within that and you're out of status here, but you are the immediate relative of a U.S. citizen, then it is still a possibility. Being the immediate relative of a U.S. citizen means you're the spouse of a U.S. citizen, you're the parent of a U.S. citizen, and the U.S. citizen is 21 or up, or you're the son or daughter of a U.S. citizen and you're under 21 and unmarried. That if you came into the country, you came in with a visa, or you came in with permission, then adjustment of status could be for you. There are other options if you're out of status, and that comes down to what kinds of situations are you facing. For example, there's VAWA. If you are being mistreated by a U.S. citizen or legal permanent resident spouse, a parent, or a U.S. citizen son or daughter who's 21 and up, then even if you're out of status, you could apply for VAWA and adjustment of status and obtain a work permit while you wait. Then there is, if you are a T visa or a U visa holder, you can then also apply to adjust status after 3 years of having those. Happy New Year, Jewel. Thanks so much on YouTube. Thank you so much for, and I wish you a prosperous New Year. Now, Keisha, you said that you would like a consultation, and this is for anyone who's listening. You would like a consultation. You can do that by going to you can call 561-405-4889. When you do that, you can then speak with a scheduling coordinator. Right now, there's an after-hours receptionist who is available. But Monday to Friday, there's a scheduling coordinator who's available between 9:30 a.m. and 11 p.m. They can go ahead and assist you. You can also schedule your own appointment by just going to the link in the profile, and you can click on the button and go through the form. There's a button that says schedule your own appointment. You can do that and you will be good to go. Hi there, 49 Drake. So now I'm going to head on over to Instagram. So if you want to continue this conversation, it doesn't have to end here tonight. If you can't join me on Instagram in a minute, I will be here tomorrow night at around 9 p.m. Eastern time, where we can continue to have a good conversation. Now, one thing I want to say is that if you don't, and I want to close this out by saying, if you don't qualify for adjustment of status, then there's always consular processing. Now, if you're here without status and you don't qualify for adjustment of status, there is what's called a waiver process if you have a U.S. citizen or legal permanent resident spouse or parent who will experience extreme hardship if you don't get the green card. And so the takeaway here is that don't give up, get legal advice, get legal representation, because there are ways to still get around your immigration status, to fix your status to get permanent residence anyway. It may take a little work, but there are ways. That's where you need to schedule a consultation to determine whether you could qualify for these ways. Now, I'm looking forward, hopefully, to speak with you in a consultation in the coming weeks, or to continue to see me on the lives where you can always bring your questions and I will bring my topics. I will see you tomorrow, or I'll see you in a minute on Instagram. Have a great night. And also, if you're coming on late, you missed the live, if you go to Instagram, I'm the immigration attorney on Instagram. So same as TikTok, same as YouTube, on Instagram, I'm the immigration attorney. If you head on over there, you will be able to still watch the live that I'm going to post afterward. So it's a good way to catch up on the topic if you miss it here. And also join on YouTube. YouTube is also posted there. So it is the immigration attorney on YouTube, and it's posted right away. So right after I come off of this live, you'll see the live where I just discussed and I answered really good questions tonight. Have a good one, everyone. I'll see you tomorrow or in a consultation.